Hi everyone, we'll get started shortly. I just want to confirm that I'm actually live. All right, give me 1 second. We'll get started in just a minute. All right. Thank you so much for joining me this afternoon or evening, I should say, for this Living Trust presentation. I trust that you are able to hear me. If someone would be so kind to type in the chat, just confirming that you can hear me. Let me see here. All right, just give me 1 second here. Let me just get situated. All right, so I think you can hear me. Um, Before we begin, I need to go over some housekeeping matters. First and foremost, this Living Trust presentation is for informational purposes only. Okay, thank you everyone for confirming that you can hear me. Okay, like I was saying, first and foremost, this Living Trust presentation is for informational purposes only. It is not intended to serve as legal advice. If you need legal advice, you need to consult with an attorney, whether it be my office or any other attorney. Secondly, by you watching this presentation, it does not create an attorney-client relationship. What that means is that by you simply watching this presentation, that does not make me your attorney and it does not make you my client. I would be more than happy to represent you in any legal matter that you need assistance with, but first you would need to schedule a consultation with my office and then sign a retainer agreement. Third, I am only licensed in the state of California. This presentation is intended to serve as legal advertisement in the state of California. Therefore, if you are outside of the state of California watching this video, it is not my intent for this video to serve as legal advertisement in whatever state you are in. All right, so now that we got those disclaimers out of the way, let me introduce myself. My name is Georgina Lepe. I am the founding attorney of the Lepe Law Firm. We are located in Claremont, California. Claremont is in Los Angeles County. For those of you that are not familiar with Claremont, we are actually the last city in Los Angeles County right before San Bernardino County. My office assists clients in Los Angeles County, San Bernardino County, Riverside County, and a few in Orange County. I have been licensed as an attorney since 2010, and I am a certified specialist in estate planning, trust, and probate law by the California State Bar, and I am also licensed as a real estate broker. My firm focuses on three different areas of the law. One being estate planning, second, probate law, and last but not least, real estate litigation. Within my estate planning practice, we prepare trusts, wills, financial powers of attorney, advanced healthcare directives, and other documents that are normally included in an estate plan. When a person creates an estate plan and they pass away, that trust needs to be administered. So we also handle trust administration matters. Within my probate practice, we administer probates and handle probate litigation matters. But also with my estate planning practice, we also handle trust litigation matters. And last but not least, within my real estate practice, I handle partition actions, quiet title, fraud, breach of contract, and other issues that pertain to ownership of a property. During today's presentation, I am going to discuss the benefits of having a living trust, the differences between a trust and a will, the downfall of not having a trust, Medi-Cal Estate recovery, and much more. If you have any questions, I ask that you hold off on submitting your questions until the very end because it's very likely that I will address your question during this presentation. I will only be answering questions that are general in nature. So if your question is too specific or it's concerning a current case, I will be unable to answer those questions. All right, so let's get started. How I structured this presentation is going over the three options that I tell everyone they have when it comes to planning for the future and how they want their assets to be distributed upon their passing. Everyone has three options. So let's start with option number one. With option number one, you pass away and you did not have a will prepared during your lifetime and you did not have a living trust prepared during your lifetime. So you pass away and there's nothing in writing that indicates how you want your assets to be distributed. In this situation, you are basically telling the State of California, you decide how my assets should be distributed upon my passing. Even though I worked very hard for my assets, I'm the one that acquired the assets during my lifetime. I want you, the State of California, to decide how my assets are going to be distributed upon my passing. You are also allowing the State of California to dictate the amount that the attorney that is handling your estate proceeding is going to charge your heirs at law. And last but not least, you are leaving the door open to any creditor that you may have during your lifetime to file a claim in the probate proceeding to get paid for whatever benefits they conveyed to you during your lifetime. These creditors include the Franchise Tax Board and Medi-Cal. So with this option, you're telling the State of California, make sure that Medi-Cal gets paid back every single penny in benefits that they conveyed to me from the age of 55 until my passing. With option number one, since you did not leave a will, you did not have a trust, probate needs to be initiated. And you may be asking yourself, Georgina, what is probate? Probate is the court process that needs to be initiated when someone passes away with or without a will. In a probate proceeding, the judge nominates a personal representative to work closely with the attorney to gather your assets, pay off debts, file your tax returns, sell your assets, and at the end of the probate proceeding, distribute your assets pursuant to the probate code. So remember, since you didn't leave anything in writing, the State of California, pursuant to the probate code, is going to dictate who are going to receive your assets. The downfall with probate is that it takes about 2 years to finalize. This means that your heirs at law will not receive their inheritance until the close of the probate proceeding, once the judge has signed the order for final distribution. And like I mentioned, this takes about 2 years. Secondly, probate is very expensive. We as attorneys, pursuant to the California Probate Code, charge a percentage of the market value of your estate. So I'll give you an example. Let's say at the time of your passing, your estate, your assets going through probate are worth $900,000. In Southern California, this is very easy to meet this threshold because any house in Southern California is worth at least $500,000. So let's say that when you pass away, your estate is worth $900,000. This means that the attorney is going to charge at least $21,000 in order to handle your probate proceeding. And the reason I say at least $21,000 is that we have the ability to ask the court to increase our fee. If we were required to engage in certain tasks that we normally do not engage in any normal probate matter. So we, the attorney, let's just say we're going to get $25,000 because we provided an itemized statement to the court outlining all the additional time that we spent on your probate proceeding, and then we multiply that by our hourly rate. So let's say we ended up at $25,000. Well, the personal representative, the family member that is working with the attorney, is also entitled to that same amount. So 25,000 plus 25,000, that is $50,000 that is paid out in personal representative fees and attorney's fees. This does not include the court costs or any claims that may be filed by any creditor, including the Franchise Tax Board or Medi-Cal. Third, in a probate proceeding, a judge is going to determine who your heirs at law are pursuant to the probate code. The judge is not going to hold an open forum and say, okay, adult children, which one of you is entitled to a little bit more because you're the one that took your mom or your dad to all their doctor's appointments. You're the one that was always there for birthdays and holidays, and which one of you hasn't called your parents in the last 10, 20 years? The judge isn't going to hold an open forum to inquire as to who deserves the inheritance. Based on the probate code, if you're a single person or you're married but your spouse predeceased you, then your assets will be distributed in equal shares to your children. That may be what you want, or it may not be what you want, but it doesn't matter at the end of the day because you decided to leave everything in the hands of the state of California. So the judge is going to determine how to distribute your assets. And last but not least, like I mentioned, probate opens the door to creditors. So if you owed any money during your lifetime, they can file a claim, and these creditors get paid prior to any distribution being made to your children. So yes, it's kind of risky leaving everything in the hands of the state of California to make decisions for you when you definitely have the opportunity to create a will and a trust during your lifetime. With all this being said, at the end of the day, title controls. What I mean by this is that in certain situations, probate may not be necessary because you do not have any assets that are subject to probate. So you may be thinking, well, Georgina, you know what? I have 3 kids. I don't want to waste my time and money creating a trust, so I'll just let my kids go through probate. It doesn't matter. They can pay the statutory attorney's fees, they can pay all the creditor claims, and they can wait the 2 years to finalize the probate proceeding. The problem is that you have to look at how title is held, how you hold title to your assets. I encounter a lot of situations where people have bought investment properties 20, 30 years ago, and they don't even realize that how they hold title has legal consequences, and they may be disinheriting their children. I'll give you an example. Let's say you purchase an investment property 30 years ago with your brother. You were single, your brother was single, you wanted to invest, you decided to purchase a rental property. You were young at that time. You don't even remember the entire transaction. You don't even remember how you took title. Well, if you hold title with your sibling, your brother, your sister, as joint tenants or as joint tenants with the right of survivorship, when you pass away, your interest in that property automatically goes to the surviving joint tenants, automatically. So if you're thinking, okay, I have this investment property with my brother, and when I pass away, my kids can go through probate and they'll receive my 50% of the property, that's not going to happen. Because how you decided to take title, you're basically telling the state of California, when I pass away, probate's not necessary because I have decided that when I pass away, this property will automatically go to the other owner on title. This only is the case if you took title as joint tenants or joint tenants with the right of survivorship. The proper way to hold title with someone that's not your significant other is as tenants in common or in the name of your trust. But I don't want you to lose any sleep tonight over this. You can actually sever the joint tenancy. So we can record something in the recorder's office indicating that you no longer wish this property to go to the surviving tenant upon your passing. We record a document either transferring your ownership interest into the name of your trust, so that would sever the joint tenancy, or we record another document indicating that you wish to hold title as tenants in common. Another asset that my clients mismanage all the time, and when I say mismanage, is they engage in certain transactions to accomplish a certain goal, but they don't understand that their conduct has other implications and not just the desired goal. What do I mean by this? Bank accounts. It is very common for my clients to tell me, Georgina, I have 5 bank accounts, 4 bank accounts, whatever the case may be. And my daughter, she's the one that always helps me pay all my bills. So I want her to have access. I want her to have a debit card. I want her to be able to see all the transactions online. I want her to be able to withdraw money from the account, because if I don't have time to go to the bank, she can just swing by an ATM and get the cash I need. That's fine. That's understandable. However, the way my clients normally go about this is that they'll add that daughter as an owner to that account. And by you adding an adult child, whether it's your daughter or your son, to an account, what this means is that your child is now an owner of that money that is in that bank account. So if your child has any creditors, those creditors can actually go after the money that is in that account in which you decided to add your children. If your children get divorced, guess what? The attorney representing their spouse will, 1, add you as a party to the divorce proceeding, and 2, claim that the money held in that bank account is a community asset and that your child's spouse is entitled to a portion of those funds. So I always tell my clients, do not add your children on title to your bank account. If you want your children to have access and have the ability to withdraw funds at an ATM, then list them as an authorized third party or as a power of attorney, whatever the bank wants to call it. This will ensure that your child is not listed as an owner of that account, but they still have the ability to withdraw funds from that account for your benefit, see the activity online to make sure that there's no fraud going on with your bank account. So keep that in mind, because if you do add your child to that account, when you pass away, they are now the owner of that account and they have no legal obligation to share any part of that inheritance with any of your other children. Also, if you are simply relying on how you hold title to your assets to avoid probate, and you are part of a blended family, you are disinheriting your children, possibly. What do I mean by a blended family? This means that you have children from different relationships. So let's say that you have a daughter, and you were never married. You had this daughter from whatever relationship you had during your lifetime. Years go by, you meet someone, you get married with this person, and at that time you decide to sell your home that you already had, and you acquired about $400,000 from the sale of your home. And you and your new spouse decide to buy a property together, and guess what? You're going to put down the $400,000 that you received from the sale of your property. And when it comes time to deciding how you're going to take title, you decide to take title as husband and wife with the right of survivorship. Well, this means that if you pass away, the house goes to the surviving spouse. So let's suppose that you're in a car accident and you pass away. Well, guess what? You you have essentially disinherited your daughter, because the second you passed away, that house goes to the surviving spouse, which is your husband, and he has no legal obligation to share any part of that inheritance with your daughter. So the $400,000 that you acquired before your marriage and that you contributed towards the purchase of that home, your daughter's out of luck. She has zero claim to that money. So if you're part of a blended family, it is imperative that you sit down and plan for the future, because you are possibly disinheriting your children. The outcome of how your assets are going to be distributed upon your passing may be something completely different from what you have in mind. Okay, so I think that's all I want to say with option number one before moving on to option number two. So with option number one, what I want you to remember is that you are allowing the state of California to decide how your assets are going to be distributed upon your passing. You're allowing the state of California to decide how much the attorney that is handling your probate proceeding is going to charge for the administration. And you're telling the state of California, please make sure to pay back Medi-Cal every single penny that I owe them for the benefits that they conveyed to me during my lifetime. Oh, and also don't forget about the Franchise Tax Board and any other creditor that exists out there. That's basically what you're saying if you don't have anything in writing. So let's move on to option number two. Option number two is you prepare a will. What is a will? A will is a very simple document where you identify yourself and you nominate a family member or friend to be in charge of the probate proceeding. And this person is given the title of executor. In this will, you are telling the judge how you want your assets to be distributed. Keyword, telling the judge how you want your assets to be distributed. So with option number two, your estate is going through probate. And you would not believe how many times I hear every single week from individuals, not just in my office, but being out and about, and they tell me, oh, I thought a will was enough. Well, yes, it's enough to tell the judge how you want your assets to be distributed, but it's not enough to avoid probate. It's not enough to avoid Medi-Cal Estate recovery. It's not enough to avoid the probate statutory fees for the attorney. It's not enough to avoid the 2 years that your heirs have to wait to receive their inheritance. The good thing is, with the will, you're telling the judge, this is how I want my assets to be distributed. You're not relying on the California Probate Code to dictate how your assets are going to be distributed. So like I mentioned, with this will, you're still going through probate. And like I mentioned earlier, title controls. That also applies to this. Going back to the same scenario that I discussed earlier, you were young, you bought an investment property with a sibling, you took title as joint tenants. It does not matter that if when you pass away, you have a will that indicates, I want my house that I own with my brother to go to my daughter. It does not matter, because we don't even get to court, because by operation of law, that house that you have with your sibling automatically goes to your sibling. So yeah, I think that's all I want to say about option number two. You're still going through probate, but the difference is you're telling the judge how you want your assets to be distributed, and you have to remember that at the end of the day, title controls. Probate may not even be necessary. You may not have assets that require a probate proceeding. All right, so now let's go over the third option and the best option, which is having a living trust. And what is a living trust? A living trust is an agreement that you create during your lifetime. In this agreement, you nominate a family member or a friend, and they are given the title of trustee. In this living trust, you leave instructions as to how you want the trustee to distribute your assets. Notice that I did not say you left instructions for the judge. No, you left instructions to the trustee, indicating how you want your assets to be distributed. What are the benefits of a living trust? A properly drafted and properly funded trust avoids probate. What does this mean? This means that Medi-Cal does not have to get repaid. It does not matter how much you owe Medi-Cal because they conveyed a certain amount of benefit to you during your lifetime. If you have a trust and your estate is not going through probate, Medi-Cal will not seek to recover. The key word there is your estate is not going through probate. It is not enough to just have the trust because as I'm going to discuss briefly, only a properly funded trust avoids probate. And what does that mean? That means that all your assets need to be titled in the name of the trust. Many people have trusts, but they forget to transfer title of their assets into the name of the trust. So that basically doesn't get us anywhere. So what are the benefits of having this trust? One, like I mentioned, it avoids probate. We're not going to pay Medi-Cal. We're not going to have to pay the high statutory attorney's fees. We're not going to have to pay the personal representative the same amount that you're paying the attorney. But what I did mention was that only a properly funded trust avoids probate. What do I mean by that? The last recorded deed to all the properties that you own needs to reflect the name of the trust. I'll give you an example. The name of my trust is the GL Living Trust. Title to my properties, if I pull the last recorded deed, it should have listed as the owner, Georgina Lepe, as trustee of the GL Living Trust. What if I were to refinance or do a home equity loan? If I engage in a financial transaction with my home, I have to make sure that the lender either completes the financial transaction in the name of my trust, or if the lender needs to take title out of the name of the trust and put it in my individual name to complete the financial transaction, I need to make sure that the lender puts title back into the name of the trust, meaning that if once the financial transaction is done with, I look on title, the last recorded deed will have the name of your trust. And that's where a lot of individuals that have trust end up in probate because during their lifetime, they refinance and they forget that they need to transfer title of their properties back into the name of the trust. If you have any businesses, your interest needs to be assigned to your trust. So for example, I have a corporation that runs my law firm. That corporation, the stock certificates have been issued to the name of my trust. So if I were to lose capacity or pass away, my successor trustee can manage my business, either sell it, close it out, whatever needs to be done in both situations, whether I lose capacity or I pass away. Your financial accounts either need to be titled in the name of the trust or they need to list beneficiaries, payable on death designations. So the most important aspect of having a trust is making sure that all your assets are actually titled in the name of the trust, and this is called funding. I always tell my clients at the end of the day, the time that you spent creating the trust, the money that you paid my office will go down the drain if you do not ensure that throughout your lifetime, all your assets are titled in the name of the trust. A lot of people believe that just because the assets are listed on a schedule of assets, that's enough. No, what matters is title. So whenever clients come to my office with the trust that their parents created and they want me to administer it, they'll tell me, "Oh, Georgina, all the houses are listed here on the schedule." I really don't care. What I'm looking at is title. So yeah, I'll take the list of the properties and I'll run a title search to confirm that every single property is titled in the name of the trust. And if it's not, then we end up in probate court. You may be thinking, well, Georgina, what if I created my trust 10 years ago and after that I acquired more assets? Well, you have to make sure that someone prepares a trust transfer deed so that those additional properties are also titled in the name of the trust. The second benefit of having a living trust is that if you were to lose capacity, your successor trustee, the person that you have nominated in your trust, has the ability to manage your assets during your lifetime. And this is extremely important, especially if you have a business or two. Because if you were to lose capacity and you're at a point where you can no longer go back to work and that business needs to be sold or closed out, or it's gonna, or your trustee decides to continue with operations, if you do not have a trust, a conservatorship will need to be initiated, a conservatorship of the estate, so that the court can appoint someone to manage your finances during your lifetime. However, if you have a trust and you lose capacity, it makes things a lot easier because the person that you have nominated as the successor trustee can manage your assets and provide for your well-being. Third benefit is if you were to pass away and your children are minors. In the trust, you're going to leave detailed instructions as to how you want your assets to be distributed. If you were to pass away right now and you don't have a trust and you don't have a will, and probate gets initiated so that your assets can go to your children are going to be in probate court until they reach the age of 18. The reason being is that a guardianship of the estate will be necessary so that the court can appoint someone to manage the inheritance belonging to your children, and every single year they're going to have to go back to court, render an accounting to the court, and for certain transactions they actually need to ask the judge for permission to engage in those financial transactions. On the other hand, if you have a trust, you pass away and your children are still minors, your successor trustee is able to provide for your children without court intervention. The successor trustee owes a fiduciary duty to your children to make sure that, the trustee follows your instructions and your children are taken care of. So that is a great benefit because your kids won't be involved in that guardianship of the estate proceeding. Talking about children, I know some of you have children with special needs. And I'm sure you're well aware that if a child with special needs receives an inheritance outright, they will lose their government assistance. And that can be very detrimental because, they are relying on these therapies and so forth that they need throughout their lifetime. So the way to go around that is by creating a trust and indicating that whatever you're leaving to that child that has a special need, for it to be held and administered in a special needs trust so that they don't lose their government assistance. So if you were to pass away and you don't have a trust and probate gets initiated, then the executor, well, not the executor, the administrator of your estate is going to have to petition the court to be able to create a special needs trust for your child, which will result in attorney's fees being incurred at that time. With the trust, like I mentioned earlier, you are listing beneficiaries. You are indicating how you want your assets to be distributed. It is perfectly fine to disinherit your children. Just don't tell my parents that that's possible, but you can disinherit your children if you want to disinherit them. There is no obligation in the state of California to leave a distribution to a child. I do have clients that disinherit their children for several reasons, and others wish they could disinherit them, but they feel bad disinheriting them. So unfortunately, they still get a distribution within the trust. You may have a child that is not very responsible and you don't trust that they will be able to manage their inheritance upon your passing, and you would hate for your hard-earned money to go down the drain within a week of your child receiving that money because they're just going to blow it on dumb stuff. So in your trust, you can actually stagger the distributions and say, well, I know Johnny's already 50 years old, but he still can't manage his money. So I want my trustee to manage his inheritance and simply pay for his living expenses, pay for his rent, pay for his groceries, and whatever other expenses he has. So that's definitely possible in the trust. And with a trust, blended families are protected. So if you have children from different relationships and you were to predecease your spouse, you can ensure that that child or children that you had prior to getting married to your current spouse, that they are taken care of, whether it's a specific distribution and you say, well, if I pass away before my husband, I want my husband to give $100,000 to my daughter for my previous relationship, or my daughter's going to get half of the house that I own with my husband, but he has the right to live there and throughout his entire lifetime, and then once the house sells, she'll get a portion of the sale proceeds. So with the trust, we can really plan for your specific situation. We can address your concerns, what worries you, and make sure that your children are provided for. Now I'm going to go over some common questions that I get all the time, or misconceptions. The main one is that you need to wait until you pay off your entire mortgage to create a trust. And that is absolutely false. I get so many clients that come in and say, Georgina, finally I can create this trust because I just paid off my home. And then I'm like, well, I regret to tell you, you could have done this many years ago, because if you would have passed away while money was still owed on this mortgage, probate would be necessary because your children wouldn't be able to communicate with the loan servicer without a court order. So I do have an Instagram video on this, but if you pass away and you still owe on your house and you have a trust, your successor trustee can actually communicate with the loan servicer and continue making payments. The same would be if you lose capacity. However, if you don't have anything in writing, you don't have a trust, you don't have a power of attorney, if you lose capacity, no one's going to be able to communicate with the loan servicer, and a conservatorship of the estate will be necessary. If you pass away and you don't have a trust, same thing. Your children will not be able to communicate with the loan servicer. So yes, even though you own property and you still owe on it, you can create a trust at that time. I actually recommend that you create a trust upon the purchase of any property. The other misconception is a lot of people believe that if they're not going to sell their parents' home, that probate is not necessary. They just think that magically they can go and record something at the recorder's office indicating that they are the living children of the decedent and that the house belongs to them because they're not going to sell it. No. Probate is necessary whether you're going to sell the assets or you want to transfer the assets into your name, because remember, there is a process. We need to gather the assets. We need to determine who the heirs at law are. We need to pay creditors. We need to pay Medi-Cal. So yes, probate is necessary even though you do not plan on selling the home or the properties. Another misconception is I've done probates where my client tells me, Georgina, I am the only child of my mom. Why do I need to initiate probate? Isn't it just common knowledge that I am the only child and I am entitled to everything? Unfortunately, I wish it was that easy, but it's not. We still have to initiate probate. Can I make changes to my trust? So long as your trust is a revocable trust that allows you to make changes during your lifetime, if you have capacity, you can make changes to your trust. So let's say that at the beginning, when you created your trust initially, you had equal distributions to all your children, but then you realize that one of your kids doesn't deserve it for whatever reason, then you definitely come back and make changes to your trust. Can I sell my assets once I have transferred them into a trust? And the answer is yes, so long as you have a revocable trust and the trust doesn't have a provision that prevents you from selling the trust assets. So it's very common for my clients to sell a property they have and buy another property. Just make sure that whatever you acquire is actually titled in the name of the trust. Another question that I get asked is, can I refinance once I have transferred my property into the name of the trust? And the answer is yes, so long as there's no provision in the trust that prevents you from refinancing. Just remember, like I mentioned, either the transaction needs to be done in the name of the trust, or once the lender is done with the financial transaction, he or she should transfer title of that property back into the name of the trust. Does a trust protect against my creditors? A lot of people believe I am creating a trust. I have creditors. If they sue me, they're not going to be able to go after my assets. And that is false. A revocable living trust, your standard revocable living trust, all it does is we're avoiding probate. It is not a way to avoid creditors during your lifetime or a way to shield your assets from any lawsuits. However, your trust will protect your kids, assuming it has the adequate trust provisions that their inheritance is protected from creditors, just not you as the parent creating that trust. And this is a big one, so everyone pay attention. Hopefully I haven't lost you yet. A lot of my clients say, you know what, Georgina, instead of spending the time and money in creating a trust, I'm just going to add my children on title to the property. What can go wrong? You know, I love my kids. I intend for the property to go to them upon my passing. I don't see anything going wrong in the future. And what do I say to this? This is the absolute worst idea ever. I do not encourage you to add your children on title to any of your properties. And here are the reasons why. Number one, by adding your children on title, you lose control. So any transaction that you want to engage in concerning that property, you need to obtain the consent of that child because that child is on title now. So if you want to refinance, if you want to sell that property, guess what? Your child needs to consent. Secondly, your child is now an owner of that property. You have opened the door to the creditors of your child, including the spouse of your child in the event that your child were to divorce. It's not uncommon for the spouses in a divorce proceeding to claim that that property that you decided to add your child on title to is a community asset, and then they'll add you as a parent as a party to that divorce proceeding. Third, if you have a falling out with your child can actually force the sale of the property. That is called a partition action. My firm handles a lot of partition actions because if there are two or more owners of the property and one wishes to sell and the other one does not, a judge is not going to force you to stay in that partnership and will actually force the sale of that property. So if you've added your child and there's a falling out and they want to sell the property, guess what? They're going to sue you to be able to sell that property. And last but not least, your children lose the step up in basis. So it's always best to inherit a property, because whatever the property is worth at the time of your passing, that is the new basis for that property. So if your child turns around and sells the property, their capital gains taxes will be determined using the value at the time of death and the sales price. You lose that benefit if you add your children on title to your assets during your lifetime. What is included in my estate planning portfolios? You get the living trust, a pour-over will, a financial power of attorney, an advanced healthcare directive, and other documents concerning your personal property and funeral instructions. And we transfer your real property, your primary residence, and your income properties, your rental properties, into the name of the trust. The financial power of attorney is honestly the second most important document that you are going to sign when you come into my office. Because with the trust, you are avoiding probate and you are avoiding the need of a conservatorship of the estate if you were to lose capacity during your lifetime concerning your trust assets. But what if you lose capacity and there's an asset that's not in the name of the trust? You're going to need a financial power of attorney so that whoever you've nominated can manage your assets that are outside of the name of the trust, that are not titled in the name of the trust. I'll get to the questions shortly, but I just wanted to mention that if you are interested in working with my office, I believed I pinned to the comments my website, which lists the steps that we have in order for my office to create your estate plan. The first step is to watch this living trust presentation, which you have already completed. And then you do need to complete an intake form. Just certain sections of the intake form are required, and then you schedule an appointment to meet with me. I do not go over pricing on these presentations. The pricing is actually on my website, so feel free to go on my website or tomorrow morning call my office. All right, so now I'm going to get to some of the questions. Thank you very much, everyone, for joining us this evening. Let me start with the questions, okay? I'm actually gonna keep this presentation on my Facebook page. I'm gonna upload it to my YouTube page, and then I'm actually also on Instagram, so I'm gonna leave it there. The question from Mari: can a child birthed by an ex before a marriage make claim to your husband's estate if it was unknown until recently? Mari, that's a very complicated question. If that child that your spouse had prior to your marriage is considered to be a child of your husband, yes, they can assert a claim against your husband's estate. But it all depends whether this child is legally determined pursuant to the probate code to be a child of your husband. Mari, also, buying an investment property under an LLC can be included in the trust. Yes, so this investment property that you're buying with your LLC, the last recorded deed is going to have the name of the LLC because this is a separate entity. How do we transfer it into the trust? By an assignment of interest. You're going to sign a document where you say, all of my interest that I have in this LLC or in this sole proprietorship is assigned to my trust. But it's very important that you treat that LLC as a separate entity, because you want that creditor protection in the event of a lawsuit. You don't want them going after your personal assets. Okay, sorry. Do you take care of irrevocable trust? Right now I'm not doing any irrevocable trust. I apologize. Someone asked, do these standards apply to other states? I don't know. I'm only licensed in the state of California. Gina says hi. Hello. Oh, Vanessa says, do you speak Spanish? Yes, I forgot. I am fluent in Spanish. Let me see what else is here. Lorena is asking, can we take them off the deed after added? I'm assuming that you have added your child and you want to remove them. Yes and no. If your children agree to come off title, then yeah, you can remove them. The problem is that now you're going to have some property tax issues because when they transfer the property back to you, your property may get reassessed for property tax purposes. I'm not 100% because I need 100% sure because I need to look at how you took title and all that. So that is a complicated situation regarding property taxes. If I put my children on the deed, do I need a trust? Like I mentioned earlier, I do not recommend you adding your children on title instead of creating a trust because like I mentioned, if you add your children on title, they are now an owner of your home. They can kick you to the curb by filing a partition action and forcing the sale of the property. On Instagram, someone is asking, is probate still the case when accounts have beneficiaries? No. So if all you have, meaning all your assets is investment accounts and you have beneficiaries, you're good to go. It's when you have a home that I would recommend a trust. Sorry, the questions are moving. Clarita, is it possible to recommend customers to you? Absolutely. More than happy with your referrals. Thank you so much for the trust. Just make sure that they look on my website to confirm that whatever they need help with, I can actually assist them with. Obviously, if it's a trust, I do prepare trust, but sometimes clients need different type of assistance depending on their situation. If I Lourdes says, if I pass my property to my children while alive, will they have to pay taxes on this? Well, if you already added your children on title, they are already an owner of your property. When you pass away, they're not going to have to pay taxes. But if they turn around and sell that property, there's going to be some huge capital gains tax implications because they're not going to benefit from the step up in basis. Meaning that if they were to inherit the property when you pass away, then that's the value of the property if they were to turn around and sell it. Oh, I saw Chris help me with one of the questions. Thank you, Chris. All right, I think those. Oh, Zoila, I see you. Thank you for your nice comment. Oh, Araceli, if I'm married, been separated for 23 years, can I do a living trust by myself? We owned two properties, both under joint tenancy, been married for 50. Okay, so it appears that you own property as joint tenant with your ex-spouse. If that's the case, yes, we can create a trust and we can sever the joint tenancy so that you transfer your interest to your trust. However, it may be a good idea to complete that divorce because there may be other consequences by being legally married to someone that you are not in a relationship with. I think I covered all the questions. Oh, Lorena, can Medi-Cal come after your house for services if your home is in a trust? So no, if your home is in a trust, what the law is right now, Medi-Cal will not seek to recover unless you signed a separate agreement. But the hard and fast rule is Medi-Cal will not seek to recover if you have a trust. But there are situations where I've seen clients sign personal agreements, so that's completely different. Oh yes, on Instagram, I did answer your question. So if you have beneficiaries on your accounts, probate is not necessary because you have already designated who's going to receive your assets upon your passing. Yesenia, how do we make an appointment with you and what would we need to get started on an estate planning? Thank you, Yesenia, for your interest. Go on my website or call my office. It lays out all the steps, but in order to schedule an appointment with me, you do need to complete an intake form. So you can request it by completing a form online or calling my office. But yes, look at my website. Luz, you're from California, but I live in New Mexico. Can I make a living trust with you? It would be best that you consult with an attorney in your state, but I appreciate you asking. All right, so sorry, it's just, I think that is all. Juan, can Medicare seek reimbursement from your property if you have it in a trust? So Medi-Cal will not seek to recover if you have your assets in the name of the trust and your estate does not go through probate. So remember, just because you have a trust does not mean you're avoiding probate. There are situations where one of the assets that you have is not titled in the name of the trust, and if that goes through probate, then yeah, Medi-Cal will seek to recover. Thank you, Kina. Tomorrow I'm gonna do another one, but contact me and we'll discuss it. Um, Clarita, thank you for wanting to refer your clients. I appreciate it. All right, thank you everyone for joining me. Hopefully this was helpful. If you, like I mentioned, if you want to schedule a consultation with my office, feel free to visit my website or call my office. Thank you. Take care. Bye.